Mr. Katyal, I don't understand why you're resisting the First Amendment. Well, I do understand why you're resisting it. But let's say there's no content discrimination. It's just a ban on leafleting, and it's a ban because people don't like solicitation. So they just don't want people passing out pamphlets. It's not aimed at Jehovah's Witnesses or anything like that, like some of our old cases. Why would that fail rational basis review?
So I think it might because, as this court said in Free Speech versus Paxson, you still have to have some underlying rationality.
Yeah, people find it annoying. They don't like it. They think it affects their businesses, and people don't want to go to businesses if they're going to be accosted by pamphleteers.
But it may be a rational basis problem, but I don't think it's a First Amendment problem. This court in Rowan said that, quote, the right to engage in expressive activity generally stops at the outer boundary of every person's domain.
And that's the point.
Let me one more question. So let me take it out of the First Amendment for you. I mean, let's pretend that public accommodation laws don't exist. Because the 14th Amendment doesn't apply to private action, only state action. Let's say that a state, in the absence of public accommodation laws, decides to flip the default and say, unless the owner affirmatively consents, black people cannot enter your home.
Yeah, so I think that's one which would be unconstitutional every day of the week because it would violate the Equal Protection Clause, because the government on its face is making a racial classification. So,
because there's state action in the way the government is adjusting its property defaults.
Absolutely.
Even if there's a long history and tradition, say, in Louisiana, of this kind of discrimination at the doorstep.
Right, it would still violate the Equal Protection Clause.
Why isn't there state action here when the state is flipping the default? It's not just a matter of property law.
Right, our point is not that whether there's state action or not, it's that there's no underlying right. It's that my friend assumes, has conceded this. He said there is no right to come onto private property absent consent. And so the only question is whether the state can fill in the conditions.
Yeah, there's no right to come onto private property without consent, so my public accommodations example is right. I mean, absent a public accommodations law or in a private residence, you could turn someone away on the basis of race.
But there is no anti-discrimination component in the Second Amendment the way there is with the Equal Protection Clause, and so that's why it functions.
Mr. Katyal,
you're just relegating